In January 2013, David Gregerson became Clark County's newest Superior Court judge after successfully outpolling Judge John Woolley in an August primary. Gregerson is one of a few judges who came from private rather than public law practice.
Much better sense of which arguments are
Recently, we sat down with Judge Gregerson to talk about his transition to Superior Court.
Hello, I'm Jim Demo with Clark County Coloso. Thank you for meeting with us.
My pleasure.
First, congratulations on becoming a Superior Court judge.
Thank you so much.
You bet. And why did you seek this position?
Well, I'm a local guy from Vancouver and Clark County, and I practiced law for about 20 years. And I suppose at some point in my law practice, I just took on an interest. I was always what you might call a courthouse rat. I was down there quite a bit, and so did a lot of talking around the water cooler and took an interest in what makes a good judge, and you learn and you pick and choose from various judges in this county and other counties, and you learn what each one brings to the job, and you pick and choose and see what makes a good judge and sometimes what makes a bad judge. And so I just developed an interest. I became a temporary pro tem judge in district court, and when I started doing that work as well as arbitrations, then I got a lot of very positive feedback from my colleagues. They encouraged me to keep that open as a career option and to eventually move in that direction professionally.
Now, what was your background prior to becoming a judge?
I came from private practice. I was 20 years in practice with Dean Langsdorff at our own private firm, and I did primarily casework involving real estate, some personal injury, other litigation, the kind of practice that I call meat and potatoes, which gets you into the courthouse almost every week. It gets you in front of the judges and mixing with your other attorneys. So billing my own clients and having to collect my fees in the open market.
And you mentioned you grew up in Vancouver. Driving past the courthouse when you were growing up, did something spark your interest? It's like, someday I want to work there?
I did not have a natural interest coming out of my youth in law. My first real recollection of a strong memory of an interest was as a junior in high school. I took a law and justice class at Hudson's Bay, and Tom Lodge was the teacher Bill Lodge was the teacher who was the brother of then Judge Tom Lodge.
Oh, okay.
So we had to go down as part of our projects, we had to go down and spend a day on the bench in Clark County, and that was my first time inside the courthouse. But it really came to me later in my college years as I was choosing a major and looking at what to do after college, and the idea of law school came into sharper focus my later years in college. And I worked at a small firm in Santa Monica, California, where two very capable and kind attorneys sort of took a personal interest in me, took me under their wing, gave me some encouragement and tutelage, and then off I went.
Now, you mentioned you came from the private side versus the public side as a lawyer. How do you think the private side has benefited you as a judge?
Well, it's kind of an open joke in Clark County. We have this raging debate about whether about judges who come from either the private sector or the public sector. And at the end of the day, the result is the same. There are many good ways to forge a path if you have a judicial aspiration. The important thing is that you have, first and foremost, exposure to legal excellence, that you learn to read and write and know the law and be able to think the law and know how the court system works. Second of all, you have to have, or you should have, that breadth of life experience. You should know what regular people go through, whether it's through the criminal court system, whether it's through business and civil litigation, whether it's through the juvenile system in court. It's just like going to Portland. You can go on the I-5 bridge or the 205 bridge, or in theory you could go all the way up to Longview. Each one may have its pros and cons, but eventually you get to the same place. You get to the other side of the river. So from my perspective, I would hope that my private sector experience might bring with it a certain perspective that would complement the attributes of the other judges there already, and that together we bring a blended and diverse breadth of experience to the bench.
Now, you actually won the position back in August in the primary. When did you hear your first case?
The election was actually held in August, and because of some anomalies there in the law, I wasn't actually sworn in until January 14th. And I did hear my first case, my very first day on the bench. You might call it being thrown into the deep end of the pool.
Now, how did you prep from finding out in August you're going to be a judge to the January date?
Well, several ways. The first thing I had to do was to shut down my private practice and get that transition to a successor attorney who could take over my clientele. And then I came in with certain strengths in the civil side of the law, and then I had certain deficits or areas where I could use more improvement. And so, for lack of a better term, I hit the books in November and December, tried to prep myself and get myself as ready as possible for day one. And then in the first 2 weeks of January, I actually called up the judges there and I shadowed them on the bench, which you might call the training wheel period. And then at the very end of January, there was a statewide judicial college held up in Bellevue. Because it was an election year, we had some 54 new judges statewide. So they put on a very intense week-long course. It goes from 8 a.m. till 8 p.m. Just a real hardcore cramming course to get you ready for the responsibilities and get you minimally proficient to take your responsibilities on the bench.
For our viewers, what types of cases does the Superior Court judge here?
Well, the way I've always described it is that the court system here in Washington, if you think of it as a pie, the Superior Court is what's called the Court of Original Jurisdiction, which means that any cases or controversies which fall under a state court jurisdiction start in the Superior Court. So basically any kind of case can be brought in Superior Court. If, again, using the pie metaphor, if you carve out a portion of that, then you get what's called district court jurisdiction, which is a court of limited jurisdiction. And that means in the criminal realm, misdemeanor cases are carved out and they can be heard in district court. The felony cases remain in Superior Court. Smaller civil cases under $75,000 in dispute, those can be heard in district court. Superior Court can hear cases that have unlimited dollar value. There are other kinds of cases, such as regarding title or possession to real estate, which must always be heard in Superior Court. Juvenile matters must be heard in Superior Court. So again, that's the main difference between the two. And the thinking is that district court, if it hears some of these smaller cases, maybe misdemeanors and traffic offenses, that we could have a court that could have systems in place which could specialize and have systems in place to more efficiently process those kinds of cases. And same thing on the Superior Court and felony side, that maybe they could focus their resources for maximum efficiency to hear the cases that naturally fall under their umbrella.
I'm curious with the pie analogy. So a Superior Court roughly half the pie, or is it a different kind of percentage?
Oh, that's difficult to measure. You could measure
okay.
by sheer case numbers.
Okay.
My guess is that the numbers might actually be bigger in district court because your misdemeanors are more common. Your traffic tickets, your jaywalking, your small theft, those things are going to show up in district court.
Okay, so since becoming a judge, especially from the private side, has your view of being a judge changed? What you thought it was going to be like compared to what it is like?
I don't think so. That's an interesting question, and most lawyers get an opportunity to do some decision making, whether it's as an arbitrator or, in my case, also as a pro tem judge. And that's one of the most educational experiences you can have as a lawyer, because when you're a lawyer, you're trying to make a persuasive argument to the court. You're trying to marshal facts and law and put together a well-reasoned argument for an outcome that you're desiring. That process becomes much better and more focused once you've sat in the decision maker's chair. You get a much better sense of which arguments are going to work, which arguments are going to fall flat. So I would answer your question by saying that actually the practice of law becomes, I think one of the best things you can do as a lawyer is to sit in that decision maker's chair. Having done that, whether it's as a pro tem judge or as an arbitrator, then that's not a huge jump to go full-time and be full-time judge.
So what are some goals you hope to accomplish in Superior Court?
Well, I'm the newest guy on the team, 1 out of 10. So my first goal is to get maximally proficient and good at administering the cases that are assigned to me. That's job one. I need to know the law and the procedures, everything else that goes along with it. Once I get that level of proficiency, I look down the road in the future and I see that we're going to be having judges retiring and new ones coming in. And then I hope and anticipate to take on some more leadership responsibilities and roles to participate in shaping the direction of the court, shaping policies as we go forward, so that the court can do as much as possible with dwindling dollars. I think a pressure that all government agencies are under, trying to do more with less, and to do it better, to get good people to come onto the bench and to do our job well and to maintain maximum confidence in the public.
So when you're dealing with the individual trial, what are some of the major goals you're trying to achieve?
Well, in any given case, it's the role of the court to be a neutral and detached observer, and then, if need be, decision maker. If it's a jury trial, we are sort of like, to use a boxing metaphor, we're the referee to make sure that neither party is giving low blows, but it's ultimately the judges that score the match. So the jury are like the judges and we are like the referee. In other cases, we are the ones actually making the call. So we have to bring out the best from the attorneys and litigants that appear in front of us, to get the facts out, to analyze the situation legally, and to make a proper decision. And to do so, I would say there's two objectives. One is actual fairness in the way you decide these cases, but then also just the appearance of fairness makes a big difference. Appearances really matter in the eye of the public, and I think every judicial officer strives to maintain an image and a program within the court system that secures maximum public confidence. The public needs to know that while the other two branches of government may be political in nature and can change with the winds of politics, that the court should be largely immune from political winds, and the court should be one place where you can go where you know you're going to get a fair deal.
Okay. What challenges do you see for the courts in the coming years?
There are several. The court is an adaptive institution that responds to whatever is going on in the community. So drugs, for example, the changing in drug laws and drug cultures, and the court responds to that. The court is an information-based system, and with the information age have come a whole host of new questions, both procedurally and substantive, about how we manage our cases and about how we manage our information. And so we have a challenge. We're probably behind the times, I would say, as a court, to manage this huge volume of information where most everyone else in the world is doing these things electronically, and we still are on a paper-based system with 1 foot in the paper age, 1 foot in the electronic age. Another big challenge is that in the past 20 years, the court, because of probably sheer economics and perhaps because of availability of the information on the internet, we see a much larger percentage of people who are representing themselves in court. That means they're not having to pay a lawyer, but the lawyer is the one that has the training and the skill and the experience and the expertise to be able to handle a case. When a self-represented person comes in, what we sometimes call a pro se litigant, they may not know the law or the procedures or know how to fill out the paperwork, and then the court has to deal with people who have needs as consumers of government services but do not have the skill or the training to weave their case or their needs through the court system. And so we find ourselves having to respond and having to find a way to assist these people get from A to B, while at the same point not practicing law for them and getting too involved. Otherwise we become advocates,
right. And
that's the constant friction between being the decision maker, the neutral and detached decision maker, and being an advocate.
Now, what we talked about challenges, what are some opportunities?
Well, I think the court system, again, continues to be that entity that hopefully the people have maximum, public confidence in. So, for myself and for the judges of our town, I think we have that opportunity, especially during tumultuous political times where a lot of the populace is polarized. I see an obligation and an opportunity for us to maintain that public confidence by being neutral and detached and still reliable and non-political. I also see, as the youngest person on the bench at age 45, I see an opportunity, if I have a long career on that bench, that I can help shape the direction of that court in the future as my seniority comes up and I have more opportunities to participate in driving policy within our court.
Is there anything else you'd like our viewers to know about the court system?
Well, I would encourage everyone who hasn't had the opportunity The court belongs to you. It's your institution. Come down and watch us in action. If you get called for jury duty, take that duty seriously. It's been said that there are two places in America where Americans are all truly created equal. One is the ballot box and the other is the jury box. And if you've had a good experience with the court system, make sure to tell your friends about that. We hear the bad stories are the ones that grab the headlines, they're the most sensational. The good stories, the quiet, good work of excellence that goes on every day is not a very salacious story, and it doesn't get reported. So, you know, come down and see your court system in action, meet judges, meet lawyers, and take an interest and an investment in your institution. It belongs to all of us. It's a citizen democracy.
Well, thank you very much for meeting with us, and best of luck to you.
My pleasure. Thank you.